probably hold your applause until I'm finished, right? I appreciate your manners. Uh, I have about 50 minutes. If I am not clear, if you want to pipe up with a question, please just interrupt, okay? What I would like to do is introduce the problem hydrologically and legally, and then try and give you an explanation for how we got here. And with those two sections out of the way, I can go into the hazardous area, always hazardous for an attorney of ethics. So this is how, this is the extent of the problem. Kansas has the best water data in the world for two reasons. We require every owner of a water right to report their water usage every year. Over 50,000 water rights in the state. We know what people are using. Second thing is the Kansas Geological Survey, just up the street, has a program of about 1,500 measuring and monitoring groundwater wells that every January, people with more stubbornness than judgment, like Rex Buchanan and others, go out and hand measure groundwater wells. Together with groundwater models and the skills of the survey, we have this map. This is the map that should haunt your dreams, okay? This is an estimated decrease in the thickness of the High Plains Ogallala Aquifer between pre-development, which in Kansas would be around 1940 or so, to 2020 to 22. The western part of the High Plains Ogallala Aquifer is largely non-renewable. That is fossil water. That is water that was deposited in western Kansas at the end of the last ice age, about 12,000 years ago. That's the glacial melt that came off the Rockies. It's a very large water supply. It is very much not connected to surface streams. So it's called fossil water. It's clean. It's delicious. It requires very little treatment. It's very high quality water. That's the Ogallala Formation. The Ogallala Formation are the sands and gravels that were pushed down from the Rockies through the glacial movements, okay? If you move farther east, you get into the area around Great Bend, and that's the Equus beds, aquifer. The farther east you go, the more renewable the aquifer becomes. So there's Hutch, there's St. John, there's Great Bend. So you've got a large river channel coming in from Colorado, the Arkansas River, going through Hamilton, Kearney, Finney, Ford, and other counties, and then it comes north with the Great Bend, and then comes down to Wichita. This area is renewable. Many of these areas are renewed by the alluvium of the rivers, whether it's the Ark down here, the South Fork Republican, or the very large expanse of the Smoky Hill River. But the darker the color, the worse the problem. Many of these areas are effectively out of groundwater. If you're around Scott City, if you're in Wichita County, west central Kansas, we have real problems there. Now, you may be thinking, and I'm going to come back to this repeatedly, why should we care in eastern Kansas? We've got the Kansas River, we've got the Wakarusa, which used to be named a creek, and then someone said this deserves to be a river, which is kind of ridiculous. We now call it a river, even though it's not half as big as Stranger Creek. If you've ever floated Stranger Creek, that's a real creek. So this is why you should worry. When you pump groundwater too fast, physics always wins. All right? And groundwater that would otherwise flow to the stream is intercepted by wells, and so stream flows go down. So rivers that used to be perennial in 1961, rivers that used to flow year-round, are now ephemeral. They only flow when there is a rain or other precipitation event, like a major runoff event. Now, the arc has always, by always I mean in terms of Kansas history, since the 1880s, irrigation ditches have taken the entire river in this part of the state. The problem is the river used to reinvigorate itself with alluvial supplies after you got east of Dodge City. That's not happening. If you look at Rattlesnake Creek, this is a tributary of the Ark. This is the creek that supplies the Quivira National Wildlife Refuge. It has been pumped to death by junior groundwater pumping. For Lawrence, Kansas, I want to emphasize this huge basin between the Republican up north and the Ark down south, and that's the Smoky Hill. The Smoky Hill River originates not far east of Denver. I grew up in Denver. A friend of mine went to Smoky Hill High School in Aurora, Colorado. Okay, the basin goes that far west. It is a groundwater-dependent prairie stream. It's half of the Kansas River. The Smoky Hill meets the Republican in Junction City, Kansas. It becomes the Kansas River, flows through Lawrence, and then hits the Missouri in Kansas City. So, groundwater pumping in western Kansas on a cumulative level affects stream flows in west central Kansas, and these have been some of the hottest water management issues in the state. Pawnee, Rattlesnake, South Fork of the Solomon, and elsewhere. Okay? So, those are the only two slides I'm going to inflict upon you. Now, how did we get here? Let me try and be quick about this. We passed in 1945 the Kansas Water Appropriation Act, which is an excellent body of water law. It dedicates all of the waters of the state to the people of the state, subject to the state allocating those water supplies to private water rights. So water is both a public resource and the basis of a private property right. In times of shortage, first in time, first in right. So if we are all pumping from the Ogallala Aquifer, let's say this is a farm and irrigation meeting in Finney County, we don't share the shortage. This is not a state like Georgia or Tennessee. In the West, we follow the prior appropriation doctrine, which means if you have a 1942 right, you get your entire right before Jerry gets any, because Jerry's got a 1945 right. Okay? The reason we follow that is because it's so dry in the West that if we shared the shortage, none of us would have enough water to actually get by. It is a very stern, and here I am in a Presbyterian church, almost predestinarian aspect, okay? Now, you might be thinking, well, that's profoundly unjust. What do I do? Well, Jerry has this magnificent substitute for water called money. He could buy your water rights. Water rights can be moved in the West. We do this all the time. Jerry and I were just talking about in Colorado how they divert water from the Frying Pan River on the western slope of Colorado that flows through Aspen. It comes across the mountains and eventually finds its way into the Arkansas River. Okay? People in California and Utah and Montana and Colorado have been doing this since the 1850s, 1840s with Utah, moving water from where it is to where it needs to be. We extended that doctrine to groundwater in 1945. And so far, so good. We have a very stern water law, first in time, first in right. We also have a very stern rule. You can only get a new water right if the water is available without impairing existing rights. So far, so good. We have a system based on surface streams, and then technology happens. World War II happens. Two major things show up. The centrifugal submersible water pump, which is powerful enough to raise water cheaply enough for irrigation use. Second thing we have is rural electrification. which supplies electrical power to these pumps. We knew that the Ogallala was there. Geologists in the 1880s and the 1890s knew that. There's some neat reports from the 1890s you can pull at the survey saying, if only the pioneers knew that the water was 15 feet down there, they wouldn't have died of thirst on the Santa Fe Trail. We knew it was there. In California, they started pumping groundwater in the 19-teens and the 20s for these really high-value raisin crops. But that didn't get to this part of the country until the late 40s, mid 1950s. You had a question?
Is the water right for a set quantity?
Yes.
Or a proportion of...
No, it's for a set quantity. A water right has a priority date, a set quantity, a place of diversion where you pull the water from, and a place of use. So, once we are able to access the Ogallala cheaply, this becomes a massive temptation for every state from South Dakota down to Texas that is on top of the Ogallala Aquifer. And Kansas softens its water law. Again, you guys walked away from hardcore predestination in the 19th century. So did Kansas water law in 1957. They changed a rule. The rule was, in 1945, if a new water right impairs an existing water right, if the water level goes down at all, you can't get new water right. What does that effectively mean? We can't develop the Ogallala because any new water right will drop the water table. So the legislature made an informed decision. We'll do two things. We'll allow a new water right as long as the new water right does not unreasonably affect the economics of existing rights. So we'll grant the right. We will soften the rules for granting the right, but we'll strengthen the protections for existing rights. Now, what was the assumption in that deal? There were two assumptions. The first assumption was we need to develop the Ogallala. This is a massively bountiful natural resource. Nebraska's doing it, Oklahoma's doing it. Texas, there are no groundwater rules in Texas. Colorado is wrestling with this. Some states have the prior appropriation doctrine in their constitution. We don't, but New Mexico and Colorado do. Nebraska added it in 1912. So it's a very firm doctrine in the West. So the first assumption was we've got to develop this resource. If we don't, we're going to lose competitive advantage with other states. The second assumption was you people, my hypothetical water rights owners, if you see harm to your wells, if you see your water supplies being diminished, you're going to do the right property-based American thing and protect your water rights. So if Larry has a 1942 right, Jerry has a 1955 right, I've got a 1965 right. And I've got the money, I've got the pumps, and I've decided I'm going to have 5 cuts of alfalfa a year, and I've got a battery of 5 3,000 gallon per minute wells. Heck, why not grow rice? You know, I've got the water. The assumption was you guys would say, my wells are starting to suffer because of Griggs Farms pumping. We're going to call the state engineer and shut Griggs down because first in time, first and right. But things didn't turn out that way. Irrigators didn't protect their water rights. Why? This is a really important question. It's not about law, it's about conduct. It's about local culture. It's about local relationships, economically, family relationships, business relationships. Many of these farmers had older water rights, but they also got newer water rights as they added acreage. So they may have a 1950 right, they got a couple 1965 rights. Maybe they got a couple 1975 rights as they add acreage, as they add water to their farms. They're not going to shut down their own junior rights in order to protect their senior rights. I've heard that from several groups of farmers out in western Kansas. You also have a growth in farm sizes. The clear message from the United States Department of Agriculture in the 1970s is go big or go home. If you don't raise your acreages, you're not going to be able to develop the sort of subsidy portfolios and rotation portfolios that modern agriculture will need. So this is where we are. The fundamental problem here, the fundamental source of this scary map is that there are more water rights than water. The water term is over appropriation. The resource is over appropriated. This is a chronic problem with the prior appropriation doctrine. People claim more than the water supply can supply, or they claim more than they're actually using out of a sense of defensiveness. Okay? If this were a bank, or a business, we would call this bankruptcy. There are more debts than assets. There are more claims on the corporation than there are assets. None of the people, well, very, very, very few of them out west are breaking the law. They have water rights. How did they get those water rights? With this softened standard. The state followed the rules. The water was available. This bounty of the Ogallala, it was the state's and remains the state's duty to put that water to beneficial use. But the assumptions that undergirded this change in the law didn't work out. Most of these irrigators, to repeat, are following the law. They're not over pumping. They're just collectively, they're taking more than the aquifer can provide. Now, the law can address this situation. This is where I start my transition into ethics. I have given too many talks to the Kansas legislature. One of my goals in 2022 was to give talks at the right audiences where I would never be invited back again. I have succeeded in at least 2 forums with that. I hope the legislature will have me back. But a reflex among legislators is, well, we just need to modify the law so that we can fix this problem, which is a real technocratic, legalistic approach. I want to emphasize we can fix this problem today. It would be severe, it would be litigious, but it could be fixed. Private water right owners could bring impairment actions. They could start suing their neighbors. Kansas law provides bulletproof legal protections, first in time, first in right. Pretty prominent case out of Haskell County. Millionaire sued a billionaire. Millionaire won. The law said, what part of first and right time, first and right don't you understand? You are senior, you get all of your water. The junior was permanently enjoined from pumping ever again because his junior right was impairing the senior right. Now, this decision came down, it was absolutely correct, from the Court of Appeals, and people thought all hell was going to break loose. That there would be a flood of litigation, which of course would make me very happy because I'm training water lawyers and this is part of my job. It didn't happen. And it didn't happen because of this broader network of relationships at the local level where people know their priorities. People know the interdependence of these things. Private water rights owners can also enter into voluntary agreements to conserve water. We've seen this. I won't go into the details. In one part of northwestern Kansas, up in Sheridan County, irrigators have voluntarily worked with the state to reduce their groundwater pumping by 20%. They've actually reduced it more than that, about 25% based on KGS studies. And they haven't suffered any negative consequences because the farmers have focused on what the net on their farm is, not the gross. They've been able to work within these limits. They're extremely sophisticated irrigators. They've made it work. The state could come in. Local groundwater management districts, there are 5 of them in western Kansas, depending upon the portion of the aquifer we're dealing with. They could impose pumping cuts. The state has done this. across the state with considerable success. For example, in the Pawnee Basin watershed, right around here, that supplies the Cheyenne Bottoms State Wildlife Refuge. The State Wildlife Refuge holds a senior water right. The Kansas Department of Water, Wildlife and Parks holds that water right, and they communicated in the 1980s that their surface water right, which they need for these wetlands, was being starved of water. They asked the local GMD to request a plan to reduce groundwater pumping. The state engineer, who has jurisdiction over water rights in the state, came in, evaluated it, and imposed pumping cuts. People threatened to sue. They did sue, but then the litigation didn't go anywhere. They realized that they probably weren't going to win because of the seniority of the Wildlife and Parks water right, but also Kansas law clearly allows the state engineer, when the aquifer is in a condition of overdraft, when there are more claims on it than there is water, to reduce pumping. So, if you went out to western Kansas and said every water right in western Kansas is going to reduce its pumping by 20%, you wouldn't make a lot of friends. You would get sued. You would win. I don't want to be 100% confident there, but in the last 2 or 3 times that's happened, the courts have been very clear in saying the law is clear. The statutes allowing these reductions and the prior appropriation doctrine allow this. But no one's done that across the Ogallala, the non-renewable part. We've had these state-imposed reductions in places like Pawnee Buckner, in the alluvium of the Ark River, but we've never imposed state reductions on pumping west of there. Now, this is a lack of political willpower. Now, that may be changing. The Kansas Water Authority, which is a board appointed by various political people in the state, the governor, local groundwater management districts, they get together about every month and work on water policy. And in December, they issued a policy statement saying that the depletion, the planned depletion of the Ogallala is no longer official policy, that we cannot allow this water to be depleted at the rate it's currently being depleted. Does that have any legal force? No. It would only have legal force if the governor and potentially the attorney general and the state engineer were to agree to impose pumping reductions and then defend that decision politically and defend that position legally in court. The law is there to do that. The power is there to do that. But there's no connection between the two. And this is where I wanted to sort of devote the rest of my talk. Why, when we know that there is such a problem here, and we have the tools, this is not Nebraska. In Nebraska, we're effectively powerless to reduce groundwater pumping to protect stream flows. They follow one law for surface water and another law for groundwater. Arizona has the same problem. California has the same problem. By a terrible coincidence, those are our 3 biggest groundwater pumping states in the country. Except for the worst of all, Texas, which effectively follows the rule of capture for water. If you're a landowner in Texas, not only can you pump as much out of the ground as you want, you have physical ownership of that water. So for the state to come in and say, we've got to reduce your pumping, you run into all sorts of constitutional and legal problems where the state may be taking your property rights. We do not have those obstacles in Kansas. We can get this done, but across Republican administrations, across Democratic administrations, we have chosen not to do so. Now, this may be changing. But what connects the power and the commitment? I think this is where ethics become relevant. Do we have an ethical duty to conserve this water supply? Many of you probably have an immediate and reflexive answer. Of course we do. But I want you to examine that reflex. Of course, thanks to our new congressional district, we have our brothers in liberal Kansas all the way to Lawrence. It's actually something to think about. When Representative Mann shows up at the public library at 8:30, on Monday, by the way, ask him how groundwater pumping in the Smoky Hill River Basin is starting to harm surface water users. They're not important. I don't know, Evergy, Johnson County Water One that supplies drinking water to the largest county in the state. They are cumulatively affecting eastern Kansas. He is in a unique position to deal with this, okay? Of course you think we should preserve this water. Consider the Kansas River, the Cottonwood River, the Moretacine, all the beautiful rivers we have. They're visible, they're tangible, they're floatable. They have an immediate presence. They flow across property lines. They flow across against county lines, across county lines. But what about an aquifer? No one, much less the son of a Presbyterian minister, ever wrote a book called, An Aquifer Lies Beneath It. Okay, no, they wrote A River Runs Through It. It's much more romantic that way. Owners of groundwater rights generally own the land on top of the aquifer. They generally drill a well on their land and pump the water onto their farms. The water doesn't travel very far. And as a result, most groundwater irrigators generally believe that they own that water, that they have a right to physically possess it. That is not legally correct. I have to tell people all the time, they call me on the phone, is the state going to take my water? So we need to revisit that question, sir. Okay? But they nonetheless have a strong cultural belief that it's theirs. That belief has real cultural legitimacy in farm country. And you're also going to have to be prepared to answer a common statement across the Ogallala farm country. What good is that water doing in the ground? Why do you want to come in and tell me I can't pump water out of the ground? You also need to have an answer to the economist's reflexive point, which is $1 earned today from groundwater is worth more than $1 earned 10 years from now. The net present value of money is something that people like the Kansas Farm Bureau will always bring up. It's a pretty crude tool, right? It doesn't account for variations in commodity prices. It doesn't account for opportunity cost. That the water 10 years from now may be a lot more valuable. I don't know. Maybe growing marijuana is better than growing soybeans. Do you know that 25% of all Oklahomans now own a permit to grow marijuana? It's a fascinating cross-partisan topic. These objections matter a lot. The net present value, the economic value of the water right now matters a lot because a lot of irrigators are under intense pressure from their banks and from other creditors to maximize their revenue. They may not have the luxury of choosing conservation. So I've been working on some answers to this question and other questions for a long time. I don't think I've got the perfect answer, but I at least want you to hear my thoughts on this. More importantly, I want you to think about them as well. The first question is, what about groundwater that supplies these streams? Hydrologically, where the groundwater has a pretty strong connection to a stream. And the Kansas River Valley is a magnificent resource. I mean, if you just drive west on 15th Street and just go into the valley, if you drive along the river, there is so much tremendous water there. And you don't see any of it. It's the alluvium of the river. The river depends upon that. There is so much more water in the ground. The river is just the surface manifestation of that water supply. With this sort of groundwater, I think the answer is pretty clear. I'm confident that the only defensible answer to do we have an ethical duty to protect these groundwater supplies is yes. Because, for the 18th time, central and eastern Kansas depend upon these streams. These include large water rights. It's not just an ethical issue, it can also be a legal issue. And yes, the Venn diagrams of ethics and law do overlap to a fair extent. Johnson County, Evergy, even here in Lawrence, the largest water right in the state for the Bowersock Mills and Power Company. It's a non-consumptive right. It doesn't consume any of that water. It doesn't take that water and put it in a field or consume it through an industrial process. But it has one of the oldest and the largest water right in the state. If any of these groups, Water One, Bowersock, Evergy, decided to call their water right, that could have consequences all the way up the Kansas River to Junction City and then up the Smoky and up the Republican. So it's a property issue. It's also a habitat issue. Surface water bodies are vital to habitat. That habitat is in turn vital to many threatened and endangered species. Even if you don't care about birds, even if you don't care about whooping cranes or pallid sturgeon or other things that are endangered, the economic argument is very compelling. If we start seeing, and we will, more and more species listed as threatened and endangered, the economic consequences of a listing decision are massive. And you just have to look at the lesser prairie chicken listing in western Kansas to see that. If you don't protect your habitat, you're potentially blocking economic development in areas that where that habitat is. And if the economic development threatens that habitat, the Endangered Species Act has very strong protections to protect those species and their habitat. The Endangered Species Act is the single most powerful land use law in the world. It's not going anywhere. It's not going to be repealed. You're never going to get 60 senators to repeal it. Every time there is a controversial listing decision, you will have elected representatives say, well, in the budget rider, I'm going to have some language saying that this species is no longer endangered. Because Congress can always override the listing decision by an agency. And we're seeing that right now with the lesser prairie chicken. It's not going anywhere. So as a precautionary principle in terms of the economy, you want to avoid these creatures from becoming listed. So I think in this situation, the ethical answer is pretty clear. But political opposition to reducing groundwater pumping, even when it affects wetlands, is really formidable. I'm involved in leading litigation against the United States to protect the Aquifer National Wildlife Refuge. And that's a situation where the state was prepared to protect the senior water right held by the United States Department of Interior, Division of Wildlife, for the refuge. They have a 1957 water right. But there are about 1,100 junior groundwater rights out there that have slowly drained Rattlesnake Creek. And the wetlands are in terrible shape. The state was prepared to come in and protect the refuge, and then an appointee of the governor, the Secretary of Agriculture, along with then Representative, now Senator Marshall, and Senator Moran, intervened and stopped the state engineer from shutting down wells in open violation of state and federal law, which forced the litigation. I don't want to say more about it than that because I could be here way, way past my time. But it shows you the extent of the political opposition. Senator Moran is a very sophisticated guy. He's a lawyer. He knows what's at stake here. but he did this anyway. Now, the next question is, what about groundwater supplies that are not connected to surface water bodies? And a lot of these are not. A lot of these, even if you kept pumping them, they would have a negligible impact on stream flows. Here, some states have drawn a line. Colorado is a good example. If the groundwater is tributary to a stream, we will follow the prior appropriation doctrine. But if it is not tributary, and that's a very perverse legal definition I won't talk about, then we're basically going to allow the landowner to capture the water. What about that as a grand bargain? Well, it's a little bit hard. Should we treat this water supply differently? Does the permanent depletion of a non-renewable aquifer raise the same sort of ethical problems? It might not raise the same sort of environmental problems, but there are still important civic issues, I think public ethics in play here. If we agree that the planned and rapid depletion of the Ogallala is state policy, then we are sentencing many rural communities to death. And the people out west know that. They don't lack for candor here. The problem is, it does not strike me that they are necessarily sentencing themselves to a public death, the end of a community, the end of a town, because the people who are actually pumping the water are a very small fraction of the people who live out there. Remember, way back in 1945, farms were a lot smaller. The farming community was more dispersed, was more diverse. But because of economic forces, you've seen larger and larger farms, fewer and fewer farmers. And so the ownership of water rights in the state has become intensified among quite a remarkably small group of people. Well, the people who live in Garden City, most of them don't own water rights. The people who live in Dodge are the people who live in Huguet, and so on and so forth. So I think there's an ethical argument to reduce the depletion of our deeper groundwater supplies as well. When they run out, we won't have a substitute. But what about the farmers out west? What gives us the right, and by us I mean the center of gravity in politics in Kansas is moving ever more eastward. Look at the elections last year. I think Kelly won 4 or 5 counties, and that was enough. With the exception of Sedgwick County, none of those counties are big irrigation areas. Irrigators are not breaking the law. They are enmeshed in what a friend of mine, Matt Sanderson, who teaches at K-State, has called an irrigation treadmill, where you have market forces, farm subsidies, forcing them to pump more water than they otherwise might want to. So, do we have a duty as non-irrigators, as Kansans who claim an ethical concern about water depletion, do we have a duty to help purchase part of these water rights, or the portion of the water rights that are excessive? Should we as a public shoulder that burden? If we're going to put a lot of irrigators out of business by reducing their water rights, should we pay for that? Environmentalists can be freeloaders too, and I say that as an environmentalist. To what extent can we use the market? To what extent can we purchase and lease and retire water rights the same way we do conservation easements for land? The great Jerry Jost is here. He led the Kansas Land Trust. Incredibly capable for a long time. Can we think about a structure like that for water rights? I think there is a stereotype out there where the environmentalists are right and the irrigators are wrong, but it's the irrigators who are shouldering a lot of the economic costs, and the environmentalists are not. So look in the mirror about that. How much are you going to be willing possibly to have your taxes raised if the policy decision is we need to purchase 20% of every water right in western Kansas that is depleting the Ogallala. Something to think about. Now, the good news is, in some situations, these water rights are so crippled, they may not be worth much. Yes?
I was going to ask if you have a cost estimate for that 20%.
No, I don't. And one thing to emphasize this map, water rights are extremely local, even with groundwater, because the Ogallala Formation varies a great deal. Some of these areas, like I was just talking earlier, south of the sandhills of the Ark River, they have 100 years, 150 years of water left. Others, they're almost out. And so if you're going to value a water right, and a water right is a real property right, you know, this is something banks are wrestling with. You're an irrigator. You want 40 years of money in the sense of the loan. Some banks, until recently, weren't even asking, do you have 40 years of water? And banks are now more focused on that. I think it would very much depend. But you're looking at an irrigated acre is worth 3 to 3.5 times what a dryland acre is. And since 2008, a lot of capital has flowed into farm country to buy farmland. It's a safe asset. I'd rather make only 3% a year than lose 15% a year in crypto or more, right? This started in 2008. Every time there's a flight to safety in the capital markets, farmland goes up. Do you think Goldman Sachs knows a lot about water? Strangely, they don't. I don't know why I'm at Washburn. I should be in New York City, you know, telling them like the basics of this. Now, some of them are extremely sophisticated. Some of them aren't. So there's a lot of stupid money out there. And again, the irrigators can't compete against a real estate investment trust that has $10 billion under management. Okay? So a lot of the farmers out there, they can't buy more land. They're getting pressure from banks. It's a really complicated thing. Now, I'm a recovering historian. I'm a lawyer. I'm not a philosopher. I'm not particularly ethically sophisticated. So one of the ways I navigate through these ethical problems is through history. And here I think I'm very troubled. History can be quite a good guide to ethical decision making. What we're seeing here is incredibly rapid depletion in the space of a generation, generation and a half. That's almost nothing. Even in the span of Kansas territorial history going back to 1854. Now, that degree of water overconsumption has created a lot of economic benefits, but it has not on its own necessarily made Kansas, and especially western Kansas, a healthier place. You look at rural depopulation, farm consolidation, the eradication of habitat. And so across these questions, if the ethical thing to do is to reduce this pumping, then it seems like the public duty is clear enough. We need to do a better job of connecting these water supplies to the public. Eastern Kansas can't stand by and complain about water problems in western Kansas without recognizing that solutions require statewide commitments of resources. Western Kansas can't stand by and complain that it's being regulated by Easterners without recognizing that groundwater depletion is a statewide problem. Water flows downhill, so does the lack of water. Groundwater depletion flows downhill in smaller streams. We all need to recognize that our private property regime for groundwater hasn't done the job on its own. So what I want you to think about in closing is, what's the relationship between water and the public? In 1945, we made a really firm commitment that it was a public resource. In 1902, we sued the state of Colorado to protect the Arkansas River. And the Supreme Court said something it hadn't really said before. That when one state sues another, that state represents not just the people who own water rights, but every citizen of the state. This is called the parens patriae doctrine. So when we got $35 million in damages from Colorado, We didn't dole that money out to the owners of the water rights. We distributed that money to the public, mostly in the Ark River Basin in terms of water conservation projects. So that's where you guys come in. How do you connect a public resource that can be used as a private property right? How do you connect that to the wider public? I think ethics is a good way to do it. I'm out of time. I'll take any questions. So thank you for your attention on a Sunday morning. Yes?
I grew up in Goodland.
Okay.
And I grew up there when they were doing basically unirrigated crop breeding. And
Dryland farming.
Right. And one of my friends' father grew up in the oil fields and found out that developing an irrigation business was a great way to go. And suddenly we started growing corn in western Kansas that takes an incredible amount of water.
Right. And it's incredibly profitable, isn't it?
Yes, it is.
All right. I'm just going to be pushing back. It's my job. You cultured despisers of irrigation, to steal a line from Kierkegaard, right? I just love talking in churches. I get to drop all these lines.
Okay, so let me get to my next question. To what extent do we need to assist farmers in western Kansas in growing crops that require less water?
They are doing that already in a lot of places. So you're seeing a lot of movement towards milo, what you would call grain sorghum. Most people out there call it milo. But it's an interesting policy issue, right? You can grow 320 bushel an acre corn in Iowa and Illinois. Just say, corn, and the stuff comes out of the ground. The soils of northwestern Kansas, Goodland included, are really, really fertile if you can get water on them. A policy question is it a waste of water to grow a really thirsty crop like corn in the desert? Goodland gets 16 inches of precipitation a year. Now you're telling a farmer you can grow some crops but not others. Maybe that's okay. Voluntarily, I think a lot of farmers are saying, look, if we can make this work, and there's some really, really impressive leaders out there that I've met in Hoxie and Colby, who said, I need my grandsons to be able to live on this farm. I need to ramp it down. I'm changing my crop profiles. Corn can be feast or famine anyway. But right now, with the war in Ukraine, here's an interesting situation. Ukraine's a massive wheat supplier. Wheat prices are through the roof. If you can lock in a futures contract, okay, it's easier said than done. People who don't farm, and I'm one of them, you may have a futures contract on something that's due in October, but the drought in the last couple of years has been so terrible, you haven't been able to get a wheat crop. So I think the farmers see they need to move away from corn in some areas. A really interesting cultural distinction is between your neck of the woods and southwestern Kansas. In southwestern Kansas, the attitude is, we're not interested in voluntary reductions. There are some irrigators who have done that on a farm scale, and they've got big farms. Like one farmer, he's got 72 quarter sections. He's got 72 center pivots. Yeah, that's not a small farm, not a hobby farm. Okay, but and that's important because that farm is in the same area as the municipal well field for Garden City. Yeah.
How much does the farm bill drive those cropping patterns?
It sets hard floors for prices, which is a security blanket. Crop insurance. We've made some progress with crop insurance. For example, it used to be a very binary thing. If you have a failed crop, and this was terrible to see, and some of you have probably seen it, you have to demonstrate that you maximized irrigation. So I remember driving home from one of these meetings from Hoxie back to Topeka. It was mid-November, and there were 10 or 12 pivots going full blast. That is probably something the state engineer could have come in and say, you got to stop that, that's a waste of water, that's illegal, civil penalties. And I asked about it the next time I was out there, and they said, well, they had to prove up their full irrigation in order to get their crop insurance. Now, the feds have improved that. You no longer have to do that. It's so egregious. But, one thing to think about with this ethical issue is subsidies are part of modern production agriculture. The people on the left who hate subsidies because they're killing nature, people on the right who hate subsidies because they live in a libertarian fever dream in which, friction does not exist, they both come together and hate subsidies. But one of my policy suggestions is, instead of subsidizing farmers that way, how could you subsidize farmers in other ways? So the Conservation Reserve Program, which pays irrigators not to irrigate, has been a huge success. What about buffer strips? How about if you pay farmers not to grow crops within a couple hundred yards of a stream bank? I think a lot of farmers don't mind what the name of the federal agency is on the check, as long as the check is there. And if you can reduce the irrigation of marginal and fragile lands and pay farmers to do that largely through federal subsidies, there are promising things there. Yeah.
What I'm hearing, I think you're saying that potential solution is, and maybe it's not an either or, but either the state engineer imposes reductions, or we pay for partial rights.
We could. Generally speaking, in this world, you're going to have the federal government pay for those through programs like the Conservation Reserve Program. But, I have had clients in southwestern Kansas who have really old surface rights. And I have advised them, like, your property is only worth anything if you're willing to protect it, right? The central element in an American property right is the right to exclude. Get off my lawn, right? Go away, this is mine. If push comes to shove and you start seeing large senior surface users start calling the river, you may see a cascade of voluntary efforts to address overdraft to protect those senior rights. I don't know where this is going. I mean, I told my law students, you got 3 people in the room. The governor says, I want to do this. The state engineer says, okay, I'll do it. The attorney general says, I'll defend you. We've never seen that. Another thing is, and don't personalize this. I don't care who's in each of those chairs, because it hasn't happened. All right, they don't teach water law at Yale, so we can't blame Attorney General Kobach for knowing much about this. Okay, but I worked under General Schmidt. He understands this. He supported our lawsuit against Nebraska. So whether you're a Republican or a Democrat, that was not an easy thing to do. I had to live with that. Okay, but the political will simply isn't there. There's that great line, right? Lincoln wrote General McClellan. It's like 1863. The Army of the Potomac is like drilling, and they're walking around, they're marching. And he writes McClellan. He says, General McClellan, you have a heck of a good army out there. If you're not going to use it, can I borrow it for a while? That's how I feel sometimes. But you're talking about really blunt tools here. I think if you just go out and start doing that, the blowback is just going to be profound. But if there is an ethical belief, a public belief, one of the problems with groundwater is it's not as visibly a public resource. How do you make groundwater more public? How do you connect it to the population? The Kansas River, sure, that's a lot easier. Yes? Mm-hmm. Yeah. Maybe you should be at that meeting Monday morning. No, this is part of the culture. You are from that area. You have credibility that I will never have. I could read every water law case ever published. It's not going to help me with Representative Mann. But the fact that you grew up in Tribune, you guys, you worked and lived in Finney County, you've seen this. This is the quiet power of people from across the state. And a lot of people from western Kansas retired to eastern Kansas. I knocked into one guy. I had only met at GMD3, the Groundwater Management District offices in Garden City. Saw him every year. And then where did I see him the next time? At the Raven. So I never thought I'd see you. I'd see you in a bookstore, but not this bookstore. So, well, it's a pretty good bookstore. You know, yeah, right.
Well, I always say the grandchild brought us here.
I mean, I'll close with this, because I know we're almost out of time, but I think that's your final public question is the Farm Bureau does not necessarily represent the farmers of the state of Kansas. There's a lot of diversity, chapter by chapter, county by county, in the Farm Bureau than you would ever realize reading Farm Bureau policy statements. And the Farm Bureau effectively has a veto power in any legislation. So